before we started that process. Resolved as much as we could. And so what I thought I would do is take you on a bit of a journey, and I hope it's not going to put you to sleep, particularly if it's too early in the morning or too late in the evening. But I thought in order to explain the journey, we'd need to understand intellectual property. And in some respects, it has a very strong Australian flavour in terms of Australian law. And there are some differences between Australian and other law, but I think probably the issues might appear to be the same as we go. Then I thought I'd take you through co-design and intellectual property, and this kind of mixes a little bit because it's hard to separate them. And in terms of navigating the tensions that arise, I thought I'd tell you the tale of the two main projects where we started to explore this. And they both have different endings, one happy and one not so happy. So I guess just quickly reiterating, and I'm sure everyone understands this, that co-design really is a participatory process where all the stakeholders to a technology will actively contribute to the design of the product. And in my case, I'm particularly focusing on the design of technology. There are a couple of features of co-design, and it does depend on the type of co-design that you're doing because there are very different flavors of co-design. But the key, I guess, features are that it is around collaborative decision-making. It is about establishing an equal partnership, and in some respects, that means a shifting of power. So in that respect, where we're talking about true co-design or participatory co-design from the, I guess, Scandinavian tradition of co-design, what we're talking about there is that the people who are going to be served by whatever service or technology it is are really in control of that co-design process. And a key thing that's a feature of co-design, particularly with technology, is that it's evolutionary and it's iterative in terms of the design process. So you tend to spend quite a bit of time coming up with a solution, revising the solution, changing the solution, and then, I guess, repeating that process as you go. Why IP matters in co-design is that IP really determines the ownership of what comes out of co-design. And the different types of intellectual property that come out of co-design, the nature of those actually affects how you can use, whether that be by sharing, licensing, or commercialization, how you can use those outputs from co-design. In terms of technology, copyright is the most relevant one in co-design, but there are aspects of patents and potentially trademarks that may also apply. So in that respect, I guess the key tension that we start to explore is this concept of ownership of copyright and what people can do with the rights that arise from ownership. So when we talk about intellectual property, what we're talking about is legal rights that protect things that are created from the mind, which is why it's intellectual property. And those rights give the creators of that intellectual property control over how the work is used and how or who gets to benefit from those different innovations that they create. Now, I've got a picture of a house because essentially when we think about the rights of property, we often think about the houses that we own. And the rights are essentially the same in that you can sell your house, you can license by leasing or renting the house, you can commercialize, so for example, using your house as Airbnb to make extra money, and you can also bequeath your house, so you can put it in your will and then pass it on to family members or whoever you choose. Intellectual property is essentially the same. You have the same rights, but it's intellectual because there is no physical thing. There is just simply ideas or sometimes physical things in terms of computer code or things that are written. When we step into the types of IP, and this is quite important because different rights arise, there are four kind of major areas of IP. The first one is copyright, and what it focuses on is what's called a creative work. So that could be someone writes a novel, someone composes a piece of music, someone performs a piece of music, someone creates art. So they're all broadly covered in creative works, but that also covers computer software or the code that we write for technology, as well as, for example, the designs of interfaces and, in some respects, some of the functionality that might sit behind it. Copyright applies automatically as soon as an artifact is created. So a document, a video, a music recording, a piece of the art. So it's not something that you have to go and register. It happens automatically, the copyright and the rights that arise. The key thing about copyright is it protects the expression of an idea, not the idea itself. So if you come up with the idea for a new AI model, for example, when you create the computer code, the code itself is copyrighted, but your idea for how it works is not covered by copyright. In Australia, the rights that come from copyright are limited to 70 years from the date that it was created. So after that, they say it's in public interest that all those rights disappear, and then there's free access. So anyone can then use your creative work. Patents are a different thing, and they're really focused on the inventions. So someone comes up with a new mobile phone, for example. Patents have to be registered, and what's important is they have to meet tests around novelty and usefulness. So if someone creates a new pencil, it would be very difficult to patent a pencil unless there was something very novel around it. Patents give exclusive right for a fixed period. And again, in Australia, that's 70 years, but in different countries, that's different. And again, the rationale behind limiting how long those rights exist is because inventions eventually, particularly those that are useful for society, should become part of the public domain so that everyone can benefit from those. Trademarks, they're the things that we typically see, like the Apple logo. So these are things like brands, logos, and distinctive signs. These require registration, and again, they have to be tested to make sure that they're manifestly different to any other registered trademark. The key thing behind that is to prevent others from using similar trademarks within the same industry. So again, the issue behind this is someone creates an iPhone or something that looks like an iPhone, and they create a brand or a logo that is very similar to Apple. People might mistake it for the real Apple iPhone, and so they're trying to prevent that from happening. Last of all, there are trade secrets, and trade secrets aren't something that are formally protected by legislation, but what actually protects them is this requirement to keep information confidential. So there's no formal regulation around that, but there are laws that prevent unauthorized disclosure. And so a common one here, particularly in technology, is if someone comes up with a new algorithm, they can keep that as a trade secret. Similarly, for example, the whatever herbs and spices of Kentucky Fried Chicken is a trade secret, for example. Okay. So the real question, as I said, around copyright is who owns it? Who actually owns this idea or this expression of an idea? And so, as I said, it's based upon something tangible being created, a document, computer code, something that's capable effectively of being printed or viewed. So videos, those sorts of things can also be heard. So music as another example. When it comes to who owns copyright, there's a bit of contention around what actually contributes to this expression of an idea. So what's really clear is if you're the author of something, you're the person who was actively involved in designing it, or the coder, for example, then you're an owner of copyright. The exemption to that is an employee exemption. So if me, in my role as a researcher employed by the University of Queensland, if I create something as part of my job, then my employer owns it. I don't own it personally. There's also an area where there's collaborative work. So if a lot of people are working on something and the contributions are inseparable, then all of the contributors or collaborators are joint copyright owners. Distinct from that is, as I said, copyright law doesn't protect ideas, only their expression. So if someone comes up with an idea but doesn't write it down, it won't be protected by copyright law. It's only when it's written down or documented in some way that it then actually gets protected. And so that's why quite often when we step into this space, we have to get people to sign confidentiality agreements or non-disclosure agreements so they don't discuss. The other thing that doesn't contribute a contribution to an idea is just providing feedback. And so quite often in technology design, and similarly in some levels of co-design, we might take an idea out to people and get them to tell us what they think. That doesn't contribute a contribution to it. And so therefore, those people who give us that feedback don't have any ownership of what might be produced as a result of their feedback. As is always the case in law, things aren't always that clear. So if I give you a scenario where we have a co-design participant suggesting a change to the layout while the designer is sketching the interface, the question arises, is the participant an author since their idea changes the design, or just an idea contributor because they didn't physically sketch? Now, this is something that we've encountered because we are working with people who are living with dementia and people who are living with post-stroke aphasia. So quite often they need support when it comes to expressing ideas. And so we have someone helping them express their idea in a written format or another way. According to law, the person sketching the design is an owner of the copyright, unless there is strong evidence that the verbal contributor's input was fundamental and inseparable from the output. The question that arises in an ethical standpoint is, does this disempower the participant, given that their contribution shaped the final design? So there's quite a tension that sits in this space. And one thing that I did want to emphasize is just because something is legal does not mean it's ethical. So it can be legal, but it may not be ethical because the law really just sets out quite often a minimum standard of acceptable behavior, whereas ethics will often consider fairness, justice, as well as moral responsibility, and a number of ways of viewing that. So if we go back to our scenario and that question, does this disempower the participant, given that their contribution shaped the final design? Ethically, how do we answer that question? So one way of getting guidance on this is from the Australian Health and Medical Research Council. They set a standard on ethical conduct in human research. And so obviously what I'm talking about is co-design within the space of a research project. They have a number of principles or values: respect, justice, and beneficence. And they express those as principles, so recognizing a participant's intrinsic value, ensuring a fair distribution of benefits from research, and maximizing the benefit of research while minimizing the harm to participants. So when we apply that scenario to these ethical principles to the scenario, we should not treat copyright solely as a legal issue. Participants' intellectual contribution should be acknowledged in order for us to meet our ethical requirement of respect. In terms of justice, if the participants' ideas significantly shape the design, excluding them from ownership or recognition might be exploitative. And in terms of beneficence, denying ownership or proper attribution could actually discourage future participation in co-design and harms participatory research integrity. So from an ethical perspective, even though whilst at law, we could argue that it isn't a contribution that gives rise to ownership, ethically, we may need to take a different stance. And so that highlights the tension that exists within co-design. And I think the one for me that's most important is the fact that essentially it impacts co-design by decreasing the amount of participation people might be willing to involve themselves in co-design. And similarly, acts as a barrier to many participants actually being part of a co-design process. So the key implications that arise from that is this risk of tokenism. So we get people involved, but we limit their involvement so that they don't own it or their involvement doesn't give rise to ownership of copyright. And so in that respect, I think it's not really meeting the principles and the objectives of co-design. It's going to shift the power dynamics quickly or quite significantly, given that the idea is it's meant to be a partnership. Should the researchers or the university or the funding body actually hold exclusive ownership, that's going to shift the dynamics significantly. And last of all, even if copyright is held by the designer, we should ethically attribute the contribution of all who actually contributed to the final output. So in that respect, I think it shapes what happens with these things of intellectual property and what we should be doing as opposed to legally what we could be doing. Now, still extending this a little bit further in terms of who owns copyright. So copyright, or fundamental principle, is contribution. So you have to have made some creative contribution to the final output at the end of the day. The result is that if there's individual contribution, so for example, if I work on the training material for an app that we're building and somebody else builds the app, then there's separate ownership across those two things that occur. So each of us only owns that part that we actually contributed to. Whereas collaborative work results in what's called joint ownership. So if it's impossible to separate each person's contribution, then ownership is held collectively. And I don't know whether this happens everywhere in the world, but I know it certainly happens in the areas where law is based on the English legal system. When you buy a house, I don't know if you recall, you will have been asked if you were buying it with your partner or significant other or somebody else, whether you wanted to own it as tenants in common or joint tenants. The difference between the two is, as a tenant in common, you have a divisible interest. You can deal with your 50% of your house. You could sell your 50% to somebody else. Joint ownership means that you are one indivisible unit, even if there's 2, 3, 4, or more of you owning it. And so what that means is one person doesn't have a separate interest. You own it as a collective from there. In terms of co-design, I think, given my experience, it is impossible to separate who has contributed to what, because you've got a number of people collaborating around, for example, the design of an interface, agreeing on the functionality, agreeing on what the app should do. And everyone has made a contribution to that, but it's not divisible because we bounce ideas off each other and we work with each other. So what does joint ownership then mean in terms of some technology that we've created? What it means is that if we want to do something with that copyright, sell, commercialize, or license, everyone must agree. So every one of the owners must agree as to what's going to happen. Apart from that, we do have a separate right to use copyright for our own personal purposes, and we can use it professionally, but jumping across the far right one, all of the profit that I might make from it must be shared with everybody else. So I can't just keep that to myself. Similarly, if we are going to license or commercialize, every single person must agree. So we can't give I can't give an exclusive license to the app to somebody else. I may be able to give a non-exclusive license. So I can tell somebody they can use it. Another one of the co-designers says somebody else can use it. That's okay, provided everyone agrees and provided we then share the profits of what we get with everybody else based on contribution. So a bit confusing around joint ownership, but the most important thing behind that is everyone must agree. So what can go wrong? Imagine a situation like this. A university team is collaborating with a group of farmers doing a co-design project. They're looking at new farming equipment. What we've done is we've finally got something which is valuable, and effectively it's jointly owned because we collaborated all the way through the process by the university, because I'm employed by the university, and all of the farmers that I've worked with on this project. Someone who's a farming equipment manufacturer contacts us and says they want to license it so they can mass produce and sell the new equipment that's made. But one of the farmers is concerned about corporate exploitation. Maybe it's a Elon Musk company, sorry if I've offended anyone, and they refuse to grant the license to the manufacturer. What's the output in that situation? Effectively, we're in a deadlock. No one can do anything with that copyright because one person doesn't agree. And this scenario is something that I've taken from a research project that was conducted in New Zealand, where they came up with a new, I think it was something to do with shearing sheep or something like that. And even though they came up with this great design, it's still not commercialized at the present time because one person didn't agree. So when you're working on a research project, often, I don't know if it's the case everywhere, but commercialization is one of the big things that our funding bodies are looking for, that it can be used by other people. It would be terrible to get to the end of your project and suddenly realize there's nothing you can do because one person doesn't agree. So that's where things can go wrong with joint ownership. But let's have a look at a case study where things go right. Has everyone heard of Mozilla Firefox, the web browser? Yep. So Firefox was actually designed and developed using a collaborative co-design approach. So a lot of people contributed to Firefox. What Mozilla did was they looked at how do they maintain this ability to keep developing and working on Firefox, but also let other people work on it as well. And there were three things that they did. So first of all, their code base as computer software is protected under copyright law. But they got everyone to agree to a public license that allows anyone to use, modify, and distribute the software under certain conditions, which is generally that they can't commercialize, as in they can't make money from it, and they have to attribute. In terms of patents, whilst they could have patented some of their algorithms in Mozilla, they rejected those completely because they wanted to keep the innovation open and accessible to anyone to use. What they did do, though, was they trademarked their logo of Firefox so that the software that the Mozilla team actually developed, even though it's open source, is distinct from whatever anyone else might do if they're using their code base. And so essentially what it does, it prevents people from saying that their product is Mozilla's product. So it's all about protecting reputation and also making sure that there's a level of quality in the copies that occur of their software. Does that kind of make sense? So the key thing that they wanted to do, and I think this is very important in terms of co-design, is we do need to protect creative contributions, but we have to make sure that ownership is structured to promote collaboration. We don't want to kill co-design, even though most people are agreeing that intellectual property does kill co-design. Licensing plays a critical role, and it's about how do we decide we are going to license this, and then making sure we're in a position that we can stick to that license. So in a lot of the projects we work on, The idea is that we would like to open source the same as what Mozilla does. So that means getting agreement from people from the outset that we're able to do that. And last of all, we obviously want to protect the app or software that we produce as part of our research project. So trademarking is what we should look at doing, making sure that our version of whatever is created is clearly distinguishable from other people's versions. Doesn't damage our reputation, protects, I guess, trust and the trustworthiness of the system that we created because we were the ones that did the research to develop it in the first place. So they're the key lessons in terms of co-design. So bring all of that together. What do we need to think about with IP in terms of co-design? The first one is ownership. So who's actually owning part of it? And we do have a tension that sits around what is real contribution or creative contribution. And then we need to make sure that the rights are protected of everyone. We need to support ethical principles in terms of those sorts of things, but we also need to comply with legal principles when it comes to that. So, for example, if we want to attract copyright law, then we need to document. Similarly, we need non-disclosures and those sorts of things. We need to really clearly define commercialization and usage. What can people do with their rights in the copyright that they help contribute to create? And again, the ethical principles start to overlay that. Last of all, we need to make sure that whatever structures we create are still going to support co-design and collaboration. Otherwise, we're not doing true co-design. That part of building partnerships, I think, is the most important thing. So let me tell you two tales. I should have said at the start, if anyone has any questions, please feel free to ask at any point in time. But if there isn't any at the moment, I can start telling some stories about how we went. Is everyone okay? Okay. The first tale was co-designing an app with people who are living with dementia. So we're looking at developing a voice application on the Alexa platform that was to try and help support practice of therapy between sessions with their psychologist. When we first started this project, we contacted the university and said, what do we need to do? And they came back and said, you need a non-disclosure agreement and you need an assignment of interest in any IP before starting co-design. So let's walk through those. The first one in terms of a non-disclosure agreement. I'm sure you're familiar with them. Legal agreements are written for lawyers, not people. And I think as a lawyer, I can say sometimes lawyers aren't real people, but anyway. So they're not something that people can naturally read. And that's because the focus of a legal agreement is on risk management. The other thing is the agreement seeks to shift all power to the university because they're the ones who are writing the agreement. There's no kind of shifting power to the co-designers, it's shifting all power to the university. So if somebody breaches the non-disclosure agreement, it's not that there's any recompense to everybody else who's a co-designer, there's a recompense to the university. And last of all, big issue that we faced is because of the way it was written, people had to get legal advice before signing. And so you can well imagine that when you approach someone to be part of a co-design process and they have to get legal advice first, they're going to go too hard, not interested. And so it causes significant problem for recruitment. The other issue that we really unfortunately encountered was the legal team came back to us and gave us advice that we should not share people or information with people living with dementia, which was based on a misconception by the legal team on what it means to live with dementia, a very harmful stereotype. So we effectively had to go back to the legal team and give them legal advice about how they were breaching human rights and ask them to withdraw that. And so it sometimes helps to have a legal background, even though you're working in a different area. What we were able to do once we found a friendly person in the legal team was create a non-disclosure agreement that was what we called dementia friendly. and we used a co-design process to do that. So we had a team of people who were an advisory group looking over the top of our research project. And with them, we went through the standard legal agreement and reworded it so that it was much easier for people living with dementia to understand. The key thing that they said they wanted in the agreement was, tell me what I have to do. Because you can imagine in a legal agreement, there's lots of obligations, but it doesn't tell you exactly what you should be doing to meet those obligations. So I'm sorry, it's very small and probably impossible to read, but on the right-hand side, it's filled with examples of what you need to do to meet the obligation. So for example, in terms of not sharing information, you can't make copies, you cannot talk to other people about the details. On another page, it's like you should have a separate folder to put this in and make sure it's on your desk. So all those things were what people wanted from the agreement, so they understood their obligation. I don't think anyone had any intention or would ever have any intention of breaching the agreement. They just needed to know what to do, and that worked quite well. In terms of the assignment of any interest, the real issue that I have with this sits at an ethical level. And in some respects, I do see it as a legal level, but the legal team disagreed with me on this one. Asking people to assign their interest in something that hasn't been created is, in my view, problematic. I don't know what I'm assigning to you, yet you're asking me to assign it to you. So for me, that was a real problem. So with a little bit of fighting, even though the legal team came back to me and said, there are no legal issues with this, I said, what about if it goes to the newspaper? They said, we don't think there's any legal issue. We did a lot of toing and froing, and eventually we reached a position where instead of signing an assignment, we signed an agreement to agree. So what that meant was, instead of making the decision now, we agreed that once we knew what was created, we would then negotiate and come up with an agreement about what would happen to the IP. So it locked people into a position where they, in the future, once we knew we had to reach an agreement, there are mechanisms in place if we couldn't agree for there to be a determination that we would all be bound by. But it meant that we didn't have to make those decisions until we knew what it was that had been created. So that was useful. That was, in my view, a much better position for us to achieve both legally as well as ethically in terms of that project. Let's move on to the not so happy story. So in this situation, we are co-designing a browser extension with people living with aphasia. So web browsers, looking at ways that we can make the information much more accessible to people with communication impairment and the range of different communication impairments. Again, when we approach the university, same thing. Non-disclosure agreement, assignment of any interest to start with. In terms of the non-disclosure agreement, we were able to work with the legal team to create what we're calling a aphasia-friendly non-disclosure agreement. Unfortunately, this time we weren't able to get some of the legal words out. We still had to, they stood firm on those sorts of things, but we were able to get much simpler language, illustrations to help people understand what we were talking about, as well as bolding of text and those sorts of things. So that was again useful. Same thing, we co-designed that. We had 2 people who were living with aphasia on our research team in that project, and they worked with the legal team and myself to get this agreement redesigned and redrafted. So it's much less dense than what was originally prepared, but certainly much more easier for people to understand who are living with a communication impairment. In terms of the assignment, they refused at this point to do an agreement to agree. And unfortunately, we had to comply with the requirement for a complete assignment before starting co-design. They would not let us proceed. And the problem that we have is that we've got a funding body with deadlines, those sorts of things, and we had to keep moving with the project. So in that case, all of our co-designers have already assigned their interest in the technology that we're aiming to produce. They assigned it to the university. So this is where I'm sitting at the moment, is I'm still trying to battle this through the university as well as through some of our ethics people. In terms of legal implications of assigning, what does it mean? Participants will permanently lose their rights to any contribution they make, even if it's significant. Having said that, the university is not completely evil. It still does, when it gets an assignment, provide some share of profit if it's commercialised back to the owner. Co-designers can't use, modify, or share what they help to create. It's discouraging openness and prevent broader knowledge sharing. Many of our participants didn't understand the concept of a deed poll, the word that we couldn't get out of the document. And as a result of that, there are a number of people who elected not to participate in our co-design process. And then this requirement to seek legal advice also acted as a barrier. Even though in this case we were allowed to give people a choice, who may decide to, just the fact that it was highlighted that they should meant, again, a number of people said that they wouldn't participate. In terms of profit sharing, there is a difference, and I know this will be different from university to university, but at UQ, and I'm not particularly bagging UQ, I know it exists everywhere else, because of the assignment, the distribution of profit changes. So if somebody may have contributed 5%, they would have got 5% of the profit. Because of the way the university works, all the income goes to the university. Then after costs and tax, 1/3 goes to our commercialisation entity, 1/3 goes to the faculty where the research was based, and then 1/3 is left for the researchers and the co-designers. So in that case, the co-designer gets 5% of 1/3 instead of 5% of the whole. And that's an issue. The other thing is, because they no longer own the copyright, they can't pass it on in their will. As soon as they die, all rights cease for that person. And that's quite significant. John, you've got a question.
Yeah, it seems like the primary motivation for UQ in this case to have all IP assigned is clearly not financial because they're sharing profit. Is that to avoid the deadlock where one
So,
person, or is it more complicated than that?
yeah, I'll talk about it a little bit later on as the different ways that they could avoid the deadlock. But
Yeah.
the key thing is the university sees that it's providing the infrastructure for research. And I think that's a fair point. I think that needs to be taken into account when profit is shared. So they're providing the buildings, they're providing the computers, and quite often the grants that we get for these things don't cover those sorts of costs because the funding bodies don't allow that to occur. The issue is arbitrarily saying it's 1/3 is an issue. So there was somebody here in our school, electrical and engineering and computer science, came up with this great invention, sold it for $176 million last year. I don't know that it's reasonable to say that the university's contribution was 1/3 of $176 million.
Thanks.
No worries. Yeah, so one of the fundamental issues that I have is that this right to bequeath disappears. I think that's quite a significant change in what might normally exist in common law. So if I bring this back, and the reason I got this prepared is because I put an ethics application in last year, and the ethics committee came back to me and said, "You're doing co-design. Can you please give us an assessment of the ethical issues of co-design and what you're asking people to do in terms of assignment?" And so I've got this thing that's been sitting in my OneDrive that's about 15, 16 pages long, outlining the ethical issues of UQ's position. I probably should publish it at some stage because I think it would be interesting to publish. But if I bring it back to what are the key issues, The first one is how it violates the principles of respect and justice in our research ethics. The real ethical concern there is the power imbalance in favour of institutions. I don't know if you've heard of the term academic capitalism, but it's certainly the key flavour that sits here. I don't blame universities for academic capitalism. I blame the government for making them self-fund, but it's a very difficult environment. It undermines the principles of co-design. People are not equal partners if one person gets a greater share of what's produced at the end of the day. And similarly, it can result in that tokenistic involvement where we may make decisions about what we get co-designers to do or not do in order to limit their potential ownership in what's produced at the end of the day. And last of all, it creates this risk of exploitation, this idea that before I even know what I'm assigning, I have to assign it. And I find that a fundamentally unresolvable problem to the stance that people take requiring assignment right at the start. So for me, I guess, and I don't expect you to read this, I'm happy to share the slide deck so people can take some time to have a look through it. But I just wanted to talk through that there are, in fact, many solutions, and I'm sure in other countries, in other universities, they're already doing these sorts of things. But this idea of, how can we get around these issues and still protect the different interests, including the universities? That agreement to agree was the first one, which I talked about, which I think is quite important. In terms of loss of participant control and the unfavourable results in terms of distribution of profits, instead of there being assignment, I don't know why there can't be an exclusive license to the university. Because what that means is they haven't assigned their interests. They still have a license. They still have an ownership of the copyright. The university can still do what it needs to do, and there should be terms around that sort of stuff. But my rights still exist. If I die and it's in my will that I pass it on to whomever, then that will continue, and they will continue to get the benefit up to that 70-year limit that here exists in Australia. I think the legal complexity is a massive barrier, and I do think the lawyers, and I can speak from that as a lawyer, I think that there are ways that they can work to create these agreements so that they're accessible to people. They just don't want to. And part of it is because, again, I think I can say this because I'm a lawyer. As a lawyer, we get paid by the number of words that we write. And the other thing is, it's what makes us lawyers, the fact that we can write these things in ways that nobody else can understand. So anyway, I think the key thing that I just wanted to say here is that there are solutions. The thing that we've got to do is get universities to embrace the solution in order to support co-design effectively. Cool. That's it. I hope that wasn't too boring, and I hope it kind of addressed the sorts of things that you are hoping it would address. But if there's any questions, please feel free to ask.
Peter, thank you very, very much for that. That was great. And I will open it up to the floor for people who have comments, questions, if you want to share anything about your dealings with this, if you've had any.
Thanks, Peter. That was just realised how much I don't know about this, and yet I am, we're all involved in this space, and yet I realised I barely understand some of these terms. I guess I still don't quite understand why must people assign their IP to the university? Why can they not, if they are helping create it, why can't they have, even if it's a low percentage, or is that again the deadlock issue, or is it just the way universities are operating?
It's just the way a lot of the institutions are operating. And I do know that UQ makes exceptions to that, but just not only for certain people, I guess. So there was a fairly big project in the nanotechnology area, which was the Spinifex project, where they worked with First Nations peoples on how they could use Spinifex in manufacturing and those sorts of things. The agreement was significantly different in that space, where there was no, and You can imagine why. There's no assignment from First Nations people of their intellectual property that contributed to the Spinifex project. But when I asked the legal team as to why we couldn't do the same thing as what the Spinifex project did, they just said, no, you can't. So I think it depends upon the sensitivities that exist.
So do you see that as a piece of work that we need to do to raise that sort of sensitivity?
Yeah, I do think we do. And in some respects, I think I'm grateful that the ethics committee did ask me for this kind of exploration, because I'm hoping that will start to raise awareness. I don't know that I should send it back just to, because this was a low and negligible risk one where we were co-designing a technology toolkit with software developers. But I think if I was to take it higher, perhaps to the research and innovation committee, I might start to get a different response from that. I just think, I mean, one of the things that your duties are as a lawyer is to do the very best thing that you can for your client. And so I think the legal team are trying to do the very best thing that they can for the university with a very narrow perspective on what that best thing is. I think if they expanded the best thing as being, the university is a good citizen in terms of research, then often the best thing isn't about the best financial position. It's about the best thing that's going to facilitate research continuing to happen in the future.
Yeah, yeah. I know that they had a policy years ago that students, like research hire degree students, owned their own IP, and then there seemed to be a shift to getting them to assign it all before they even began. Is that still policy there? Yeah.
Yeah. Even like I finished my PhD in 2020. Before I could be conferred, I had to confirm my assignment of all the IP from my project to the university. The only thing that you retain is over the creative works that you create. So if you write a paper, you retain it. Sorry, John.
Oh, that's right. I was just thinking about one project I'm involved in where we have pushed the legal team to say that IP will be assigned proportional to input at a later time. Is that an example of the agreement to agree, or is that?
Yes, yeah,
it
very
is.
much.
Okay.
Yeah.
Right.
I'm glad your legal team were able to do that for you.
They were not happy.
Yeah. Yeah. The first time we got it through, it took a lot of work, but I did have somebody on my side who was in between us and the legal team, which was great. The second time it was in a different faculty and we didn't have the same person. We just hit a brick wall. I think they were horrified when they learned that we had done an agreement to agree a different project.
Yeah, we really had to, it wasn't me, but the person leading the project really had to push. And they were just like, well, why would you do this? And we're like, but it's not our creation alone. It's genuinely not. So it's, yeah.
Yeah. Especially when you're creating something that's meant to be accessed by as many people as possible. I mean, it's difficult, particularly in technology. Technology just is expensive and continues to be expensive. You can't create a technology and then expect it to continue untouched forever. Every time the phone updates, every time whatever updates, you've then got to update technology. So you need to get an income stream. That's one of the big issues. But that commercialization doesn't have to be a profit-based commercialization. And certainly the commercialized entity at UniQuest has KPIs on how much return they get, sorts of things.
Do any of the others have any comments or questions? Anything you'd like to share?
Yeah,
Richard,
I just found it really, really useful, especially what you said about lawyers working in the best interests of their clients, but maybe that best interest is quite narrow.
Yeah.
Because a lot of this IP, what you've talked about today is at odds with the kind of fundamentals of what co-production is, reciprocity, sharing power, building relationships. And so there's a kind of middle ground, or maybe even somewhere more towards co-design, I think.
Yeah.
This is really interesting and important stuff. I've learned a lot, especially, and some of the terms that I'll remember agreement to agree, because it's quite
Mm.
a term in itself.
Mm.
Um, so yeah,
Yeah,
it's really interesting.
it has
Also,
been really interesting. Yep.
it could be
Sorry, Richard.
scary for the researcher as well. I just remember getting a very small amount of money, in 2017 or something, to like a pump priming fund
Mm.
to create an app, to code create an app with people with aphasia.
Mm.
And a couple of weeks later, I got all of this stuff in an email,
Mm.
about disclosure agreements, and it was just, yeah, it was an interesting experience.
Yeah, it amazes me because I suspect that there are a lot of smaller research projects happening at the university, but they don't address this. And so I can well imagine that if something was to go further beyond just the research project itself, there could be a number of difficulties that arise. So you do have to address it. There are just ways to address it that the legal team may not initially propose to you.
Yeah.
It's very interesting, and thank you so much. I don't know very much about the laws in Europe and Sweden compared to you, but your talk has been very interesting and useful, and it really opened my eyes to these issues. I haven't been in the co-design business for a very long time, but it made me think about these important things. So thank you.
Yeah, I
Very
am
useful.
working with a person in Germany on an app, and the intellectual property laws seem to be fairly similar to Australian
Okay.
law, and we're
All right.
navigating the same thing. In that project, we're not doing co-design, so it's really just a standard technology development. So it's been relatively easy to get through. But I would be interested to hear what the laws are elsewhere, and see how it works out. In the US, it's much more restrictive than Australia.
Thank you.
Well,
No
thank
problem.
you. Also from my side, I'm from Germany, and so the laws are quite similar. And we also have some co-designing, but we always have an open source product at the end. And so that's a little bit easier. But in one project, we also had pictures. And so I was reminded of how complicated it was to do pictures with people on these pictures. We had to give them money for being a model on these pictures, so that we bought the rights from them. And so it's very important, I think, to have always lawyers with us that support us, so that we know what can go wrong and what we have to do. But we haven't really thought about the contribution of the people to the co-designing process, and so I think that's very important to implement this in this process, to talk with them about this, what this all means. So thank you very much.
No problems. It's been interesting. There's that group in New Zealand has published a couple of opinion pieces about intellectual property, and it's interesting how they talk about it as well, as being kind of this really difficult series of barriers, and how it stifles conversations in co-design and the difficulties that exist. I think it would be good to somehow get together people who are doing work in this space and start, talking about how do we approach this collectively.
Well, we are right on time. Peter, thank you very much. I think that topic has really opened all of our eyes and certainly made me think about a whole heap of things I need to do for a little tiny grant that I have that's only going to run for a year. So I've got to get moving right now. Thank you. I have actually recorded this, so I hope that that's fine with all of you. I'm just talking with Katz about where we're going to store things like this, whether it Katz has somewhere where we're able to host this, but as long as that's all fine with all of you. So thank you all very much for being here. Our next meeting is down for the 12th of May, Australian time. I think it is in the morning. I should have checked this before. So that will be Sarah Wallace talking about co-design of tech with people with aphasia. So a nice follow on from this. Peter, again, thank you very, very much. And yeah, we'll see all of you again soon.
Thank you all for coming. Much appreciated.
Thanks so much.